and we're going to look at Trump's cases from a legal standpoint. Let's get some analysis on his trial date for his election case and his September 6th arraignment in Georgia. Bill Jacobson, professor at Cornell Law School, joins us live. Bill, it's great to have you with us this morning. March 4th, 2024, that's about 6 months away. So does that give the defense enough time to go through all the defense material in the election case?
No, it really doesn't. It's a pretty shocking date. Of course, we are up against a political calendar, but that's supposedly not going to influence the judge. I don't know. That is a very quick date. If you look at the amount of material they have to get through, if you look at her schedule that she ordered, there's motions taking place practically every other week, designations of experts. I mean, this is a significant sized case. This is not a simple case. There's going to be lots of witnesses, a lot to get ready for trial. I think she set a date which really does prejudice Donald Trump in his ability to mount a vigorous and, constitutionally required defense here. So I think that's a pretty shocking date.
You mentioned that Judge Tanya Chutkan does not consider the political calendar. So what factors go into considering a trial date?
Well, she says she doesn't consider the political calendar, but it's kind of hard to imagine that when she picks a date right before Super Tuesday. The prosecution wanted it early January, and the defense, I think, made a mistake by asking for April of 2026. They clearly don't need that much time. I think if they had maybe asked for a more reasonable date, but the defense does have to consider the political calendar. So it's hard. The problem here is the prosecution brought this case in an election cycle. They could have brought it a year ago, and we wouldn't be worried about times and rushing things. So I think that the judge considers the right of the defendant to a speedy trial and the right of the people to a speedy trial or to a reasonable trial date. So I don't know how she justifies the day before Super Tuesday. Clearly that puts the defense under enormous burden to prepare their defense.
And we'll see how that impacts voters, and Trump does plan to appeal this. So what factors are to be considered there?
Well, I don't know how he's going to appeal a trial date. Maybe his lawyers know more than I do, and they very well might. But normally an appeals court is not going to get involved in micromanaging a trial calendar. After the result is in, if he's found guilty, that might be an issue for appeal, that he was deprived of the effective assistance of counsel. In fact, his lawyer said in court, at least as it was reported, that this will deprive the defendant of his right to counsel, that there's no way they can do a proper job going through all the documents within this time frame. And again, according to reports, the judge's response is, well, you don't have to review everything. You just have to review things that relate to what Trump said. And I think that's a completely ridiculous statement. Of course they have to go through everything, because it's the defense lawyer's position to decide what's important and relevant and not important. It's not the prosecution's decision, and it's not the judge's decision, at least not in terms of discovery, as opposed to what gets admitted at trial. So I think this really does deprive Trump of his right to a fair trial. Look, I've always said, and I think I've said it on your show before, that this should have been brought a year ago. I wish, if they're going to bring these charges, that they would have done it in a more timely fashion. But the prosecution didn't. The prosecution created this problem, and I don't think that you should, damage a defendant's right to self-defense and a right to defend himself, I should say, in court properly, just because the judge thinks it's better to do it. I think this is really a bad decision by the judge, but I don't know that it's appealable right away.
Right, some of the short and long-term implications of that trial date. Let's go to Georgia here. What motions do you expect to see from Trump's team at his September 6th arraignment?
Well, I don't know that there'll be motions at the arraignment. Arraignments are usually fairly short affairs, and he may even waive appearance, assuming the prosecution agrees. I know one of the other defendants was arraigned without physically appearing. But that will then trigger a lot of events that take place in the case. I don't think that judge has yet set a date for Trump's trial. I know she did set an October date for another defendant, but that defendant requested a speedy trial. So I don't know when the trial date's going to be, but there will be motions. The first one will probably be in federal court. Once the judge decides Mark Meadows' motion to pull this case out of state court and move it to federal court, Trump may follow suit. or the judge may order the whole case brought to federal court. So that's the first thing that they're going to try to do, is get this away from the state court system. And then there will be defenses like immunity, that Trump has immunity from state prosecution for things he did while he was president. And that could be disputed. What is covered by that immunity? What is not covered? Of course, the prosecution will say he wasn't acting as president, he was acting as candidate, and the courts will have to sort that out. But the immunity from state prosecution is going to be a big thing in the Georgia case.
And how does that work? Is that a motion that they try to appeal to this immunity clause?
Yeah, that's right. It will be a motion that they will make, whether it's in federal court if the case is removed, or in state court, saying that Trump cannot be prosecuted by state officials for actions that he took while he was president. The supremacy clause of the Constitution does not allow states prosecutors to interfere in the conduct of federal officials. And so that doesn't prevent necessarily a federal prosecutor from prosecuting, but this is a state official. This is actually a local district attorney. This is a local official doing this. And if you had a president who could be subjected to hundreds of such prosecutions by state and local prosecutors for what the president does while president, you could never have an effective presidency. So I think that will be a huge issue.
Some really great analysis. Bill Jacobson, professor at Cornell Law School, thank you.
Thank you.